SJC-12976, Commonwealth v. Daniel Nash, and SJC-12990, Commonwealth v. Joseph Elibert.
Ms. Capiccio, we will hear your summary argument.
Thank you, Justice Gaziano. Good morning, members of the court. My name is Rosemary Capiccio. I represent Daniel Nash. May it please the court. I'm asking this court to reverse the decision of the single justice who vacated the trial judge's order staying the sentence of Mr. Nash, because the trial judge's order determined that Mr. Nash raised an issue that had a reasonable possibility of success on appeal. Mr. Nash was not a danger to the community because he had no record. He had never committed a crime before in his life. He was not a sexual predator. The trial judge also determined that he was not a risk of flight because he had been on bail for 4 years, and he had had no issues whatsoever with respect to the bail order and his compliance. And the third factor that the trial judge determined that Mr. Nash met was that prison itself, according to Christie, poses an increased risk of Mr. Nash catching COVID. And therefore, even though Mr. Nash had no underlying health conditions, which would put him in a special category to cause a stay to issue, he met the qualifications for a stay and was, in fact, granted a stay. When the single justice reviewed this case, she determined that she was required to review the case de novo. And it's our belief that under Hodge, where a defendant is successful on a motion to stay, the case should have been evaluated under an abuse of discretion standard, not under a de novo standard. And although we understand that it is discretionary, we're asking this court to give some guidance to the superior courts and to the appeals courts in terms of the proper standard to be used when a defendant is granted a stay. It's such an unusual situation that a defendant is granted a stay. And because of this COVID situation, the numbers, according to the letter that was submitted by CPCS, of people who were released from prison is about 30 people who were released from prison, which really doesn't de-densify anything. When you compare it to the 1,600 people that were released from jails and houses of corrections, we need to do a better job of de-densifying the jails or the prisons in order to get ready for the second wave of COVID, which we all believe is coming.
Ms. Capiccio, I'm going to just interrupt you because I neglected to do something. One of the issues that's raised in this case is whether it's the Commonwealth's sole recourse after stay is issued pending appeal to petition on the county court under 211 section 3. Justice Lowy is recused from that. He made that decision. He's recused from that matter. So we're going to decide that issue to the extent either counsel, Ms. Capiccio hasn't raised it, but to the extent other counsel wanted to argue that issue, that's going to be decided on the papers.
Thank you, Justice Gaziano.
So forgive me, Ms. Capiccio, you can sum up.
Thank you, Justice Gaziano. We were informed by the clerk that that issue was submitted on the papers.
Of course you were, because it's Clerk Keneally.
Right. And the other things that I'd like to raise is that the single justice erred in finding that Nash had no reasonable possibility of success on the merits. Under the case law, a reasonable possibility comes down to raising a non-frivolous issue. Nash raised a number of non-frivolous issues, in particular one issue regarding the 911 call, which was later solidified by the court and supports Mr. Nash's position. The final issue that I'd like to raise with the court is that if Christie was meant to de-densify the prison system, it was not supposed to be an insurmountable impediment to release. And that is in effect what it has become. When this court,
Ms. Capiccio, okay, let me just ask you, because I understand that. My question to you is, you said that the single justice thought that she had to rule de novo. Is it not your understanding that she had either the opportunity to rule either de novo or for abuse of discretion?
It is my position, Justice Budd, that she had the opportunity to use her discretion to rule either way. What I'm suggesting is the case law suggests that when a defendant is successful on a motion to stay. The proper standard is to review for abuse of discretion, not necessarily review de novo. And the difference that I saw in the single justice's evaluation is she believes she was required to review it de novo. And I don't think that.
Well, you just said that according to the case law, when a defendant is granted a stay, the single justice is supposed to use the abuse of discretion standard instead of de novo?
No, that's not what I'm saying at all. I'm saying that the single justice has the discretion to review it either de novo or for abuse of discretion. But what's happening in reality is that the district courts aren't granting stays, and any stays that are granted are going up on appeal, and they're routinely getting reversed for any time that a stay is granted. And that's because there is an onerous standard right now for a defendant to meet in terms of a review de novo. So if you have a trial judge who knows this defendant, who dealt with this defendant during an entire trial, who evaluated what the proper sentence was for this particular defendant, who found this defendant was not a risk of flight, was not a danger to the community, and this seemed like after 50 letters of support that the trial judge evaluated, it seemed like it was something that Mr. Nash engaged in, that was not a situation where the trial judge was concerned at all for the safety of the public. And so if he meets those criteria, that he's not a danger to the community, that he's not a risk of flight, that he actually raised a valid issue, that he has a possibility of success, the only other issue that becomes a hurdle for defendants like Mr. Nash is Christie. And Christie was supposed to create an avenue for release, not be an impediment to release. And that's what Christie has become, because the courts are interpreting Christie as an additional burden that the defendant now has to prove that either his institution has COVID or that he has some special disease or condition that would make him more vulnerable to the considerations of COVID.
So let me just ask you, just to clarify, it sounds like you're saying if a defendant is granted a stay, a single justice should use the abuse of discretion standard, given the fact that the trial judge has all of the information that the single justice may not. But you agree that the single justice does have an option, de novo or abuse of discretion. Is it fair to say that you're saying in this case, the single justice abused her discretion by overturning the grant of a stay because of all the factors that you listed?
Yes, in addition, what I'm saying is there was an abuse of discretion in this case because the focus was on the crime. And if you focus on the crime, no one's getting out. If you focus specifically on the crime, especially a crime like this, the fact that the trial judge made comments and said that this was a horrific crime that the victim had suffered in this case shouldn't be an impediment to a stay. It should be a consideration. The crime itself should be a consideration as to whether or not to grant a stay, but it can't be the only factor that a court considers. And in this case, it appeared that there was an undue emphasis on the fact that the trial judge found this crime horrendous, that the single justice found this crime horrendous. And we can all agree that rape is horrendous, but it should not be an impediment. It's not an exclusion. There's no exclusion by this court that says if you are convicted of rape, you can never get a stay. And so the way that the single justice evaluated this argument that we made wasn't that she gave any deference at all to what the trial judge found, and instead she focused on the portions of the trial judge's decision that called this crime a scourge on society, that called this crime something that never should have happened. And we can all agree that this never should have happened, but it's not the standard that should be applied in determining whether or not a stay is appropriate. If a defendant is not a danger to the community, not a risk of flight, and he can de-densify the prison system by being let out, then he should be let out. And in this case, it's important to note that Mr. Nash has been out now for 3 months. He's had no concerns whatsoever. He hasn't violated the terms and conditions of any of his release. And to put him back in jail now, after having been on the street for 3 months, introduces whatever he's been exposed to the jail system, to the corrections officers, to other inmates. And we don't know what the effect will be in this case of having Mr. Nash go back to jail at this point, especially where he hasn't violated the terms and conditions of his release.
Okay, thank you.
Any further questions?
I have one question, and that is, can you address briefly the difference, the standard of review with regard to the legal issue? Because that's something I think perhaps an appellate judge might have a better handle on than the trial court judge. I've read in different cases, you referred to it once as a non-frivolous issue, a reasonable possibility of success. What is the legal standard on the legal issue?
Justice Seifer, are you talking about the legal issue of the granting of the stay?
No, I'm talking about the legal issue within the reason for the stay. You know, there's usually a reason. Once you've been sentenced, you need a reasonable likelihood of success on the merits on your legal issue. But that's been characterized many different ways in many different cases. I want to know what your position is on what standard is applied there.
I believe the standard is it has to be non-frivolous, Judge.
Non-frivolous.
The issue is that it has to be non-frivolous. I think that's what the case law says.
Well, that's what I'm saying. There's different case law. So what's your best case on non-frivolous?
I think the best case, Judge, on non-frivolous is the case cited in my brief, which I can't find right now, Judge.
Okay.
I apologize for the non-frivolous issue.
I'll find it. That's all right.
I apologize for that. I didn't write the case
Understand.
name down. But my position is that it's a non-frivolous issue. So it's not a determination of whether or not Mr. Nash would be successful on appeal. That's for the appeals court to make that determination. The issue here is, I think it's similar to an issue on a preliminary injunction where you have to say, are you raising an issue that has the possibility of success on appeal? And
Okay,
so you don't look at the final determination. It's not outcome determinative. And I think that's where the single justice went wrong, because she was focused on the fact that the trial judge said, I don't think you're going to have any success in the appeal court.
Ms. Capiccio, I believe Justice Kafka has a question.
I'm sorry.
So I'm trying to understand why we should apply an abuse of discretion standard when the stay is granted and de novo when it's not. What's the logic in that? I've always been confused why you have a choice between two standards, but I'm trying to understand the principle for why when it's granted, it's abuse of discretion, and when it's not granted, it's de novo.
Well, I can give you my interpretation, Justice Kaffer, of what I think the court means by it. And my interpretation is that when a defendant is granted liberty, which is what he's granted when a stay is granted, the review should be for abuse of discretion. When he's kept in jail and not granted liberty, it should be that the standard should be de novo, to take a look at whether or not the failure to grant him liberty was an abuse of discretion. That's the way that I see the difference between it. It has to do with the defendant's liberty interest and ability to be granted a stay pending appeal. The stay in this case doesn't change any of the issues on appeal. It doesn't change any of the issues that are going to get considered. It's just
Has any court ever articulated it just that way, what you just did? Any decision you could look at where it explains? Because you would think that would be sort of a simple point that would be throughout the case law, but I just don't remember seeing that.
I think the closest is Hodge, Your Honor.
Wasn't the case. I thought you said that the judge, the single justice has the option to do one or the other.
Yes, I'm saying that what he's saying is what Justice Kaffer was asking me is what's the logic behind the two different standards. I was explaining the logic behind the two different standards, not that one surpasses the other. I'm saying in this case that I think the standard should have been reviewed for abuse of discretion. Should have been reviewed for abuse of discretion, not de novo. The problem with the single justice's issue or determination is she believes she was required under the law to review it de novo. And there's no requirement anywhere that says she's required to review it de novo. So Justice Kaffer is correct when he says that we need to look at the reasoning behind Hodge and why the court in Hodge said there was this distinction. And my understanding of it is it has to do with the defendant's liberty. If you're able to win a defendant's liberty, then the review should be limited to abuse of discretion. If you don't, then this court should have, or the reviewing court should have the opportunity to review the case de novo to make sure that the liberty interest is protected.
Any further questions for Ms. Capiccio? Thank you, Counsel.
Thank you. I would rest on my brief.
Mr. Rangovitz?
Thank you very much, Your Honor. May it please the court, David Rangovitz for Joseph Elibert. Any enclosed congregate environment is not safe during this pandemic. We've seen it time and again. Schools reopen and they quickly close. Sports teams get mass diagnoses, but most pertinent here, prisons and jails are the site of 80% of the top national COVID-19 hotspots. The risk in prison is inherent. Of course, steps can be taken to try to mitigate that risk, but it cannot be eliminated. We know that because we've seen it here, first at the treatment center, then at Framingham, then at Shirley. But just look at this case. Mr. Elibert's stay was revoked on Zoom. How could anyone think it's safe to send someone back to prison when conditions are so unsafe that the court proceeding itself isn't even conducted in person? People in prison deserve the same level of protection that we give to ourselves. And Mr. Elibert is a 64-year-old type 2 diabetic. The risk to him if he's returned to custody would be both extraordinarily grave and entirely needless. He has complied with strict conditions of release for the past 5 months. He complied with conditions of release during the 4-year pendency of his case. He's a strong candidate for a stay even regardless of the pandemic, but during it, his claim is undeniable. And there's a new development. Just since my reply brief was filed on August 27th, the DOC has reported another positive incarcerated person at MCI Cedar Junction, a confirmed, ongoing, active case among the incarcerated population right now. It's in the most recent special master's report. So even by the motion judge's own metric now, Mr. Elibert should remain at liberty. It's because prisons aren't safe. Throughout the pandemic, 604 people in the DOC, both inmates and staff, have tested positive. At least 10 people are dead. According to researchers at the Harvard Medical School, the virus has infected incarcerated people at 3 times the rate it infects those in the Massachusetts general population. That risk is real and it's inherent to the carceral setting. In my career, I will never come to this court asking for less. I'm not asking you to vacate a conviction, reduce a sentence, or even release someone on a stay. I'm not even asking you to let someone remain at liberty in the community. I'm simply asking you to let Mr. Elibert remain confined to his home on a GPS monitoring device during a once-in-a-100-year pandemic. But in my career, I'll also never have a case of greater consequence because Mr. Elibert's life is at stake. There's no basis to return him to custody in the middle of a pandemic to which he's highly vulnerable when he complies with conditions of release, and the revocation of the stay should be reversed. And with that, I would welcome your questions.
I actually have a question, Attorney Rangovitz. Tell me, I understand all the arguments about the pandemic, and I'll have some questions for the Commonwealth on that issue, but are you, in terms of what the standards are you arguing that the single justice abused her discretion, or are you saying that there should have been a different procedure? Because it seems to me that the single justice was entitled to either rule de novo or to rule for abuse of discretion, and she decided on the latter. What's wrong with that?
You're absolutely correct. I acknowledge my standard of review argument is a little bit confusing, but fundamentally my point is that you should really review the motion judge's decision and not the single justice's decision effectively, because the single justice's decision is, with all due respect, a little bit incoherent because it purports to conduct abuse of discretion review, but then it doesn't rely on a different ground than the motion judge relied upon, which would be totally fine. It actually contradicts a conclusion of the motion judge because the motion judge granted the stay. So he at least implicitly concluded that there was a reasonable possibility of success on the merits on the stay prong 1. But then he reversed himself, relying completely on prong 2, the safety analysis under Christie. But then the motion judge conducts what she calls abuse of discretion review, but only rules on the first prong, contradicting what the motion judge said. So honestly, I don't know how that works. I don't know how you do abuse of discretion review while not using a different ground, but actually contradicting what the motion judge said. So my argument is that doesn't really lend itself to further appellate review by this court. So this court should essentially review what the motion judge did. And then when this court is picking between the two standards of review, my argument is it should be de novo for all the reasons I've laid out in my brief. The key one being that things have really changed in the interim with the multiple positive cases in the incarcerated population of this facility.
I'm sorry, are you saying that we have the choice of deciding de novo or for abuse of discretion as well?
That's the argument that I'm making, because I'm essentially asking this court to conduct that first level of review that Mr. Elibert didn't really get. He didn't get the appeal to which he was entitled. He got abuse of discretion review that contradicted what the motion judge actually said. And it's a level of incoherence there that I don't think makes sense and doesn't lend itself to further review by this court. I don't know how this court goes about reviewing that decision.
So I guess that's my question. Are you saying that in this particular case, we should, because of the unique circumstances here, we should look at this de novo, but normally when reviewing a single justice decision, we would look at it for an abuse of discretion?
Absolutely correct. That is my position because of the idiosyncrasies of this case that I just laid out.
Okay.
I believe Justice Lowy has a question.
Sure. Thank you. Mr. Frankovitz, are you, your position is that under Christie that COVID-19 is always a factor, correct?
Yes.
Okay. Now, are you saying that the single justice of the appeals court misunderstood Christie because she was looking at the lack of COVID cases in the institution and that there was limited risk to your client because of his age and health? Are you saying that was the error, or do you think that the single justice actually took all that into account, including the general concern about COVID-19 in her decision?
Well, as I just stated to Justice Budd, really my fundamental argument is I would ask this court to really review what the motion judge did rather than the single justice. But I think the error of both the motion judge and the single justice is just requiring what I called in my brief really a hyper-specific level of risk to this particular defendant. I mean, you see it time and again in both single justice decisions of the appeals court and panel decisions in 128 that are really seem to be requiring specific vulnerability of the defendant and sort of a looming outbreak in the particular facility.
So what your position would be, if I could just interrupt for a moment, not that you can't take that into account, and sometimes that inures to the benefit of the petitioner, but that you always have to take into account under Christie the overriding concern of COVID-19 within the institution.
Correct, and it's not, I'm not making this up. I mean, that's what Christie says. Christie says you both consider the general risk from COVID-19 to people in custody and the specific risk to this specific defendant. But I think you're seeing time and again that general risk is really being shortchanged. And as Ms. Capiccio said, it's also being seen as sort of a third additional factor that defendants need to satisfy as opposed to a subsidiary part of the prong 2 safety analysis, which is really what it is. And it's supposed to, in every case, inure to the benefit of the defendant, but that's just not what's happening.
Mr. Rangovitz, I have a question for you. As far as the general risk goes, are we to assume the general risk lasts until the pandemic is over, whether or not we look at the daily reports and we see the numbers of people who are infected in the facilities?
Yes, I think that's correct, because that's the reality of the risk in carceral facilities. I saw one study came out that the people in custody are 5.5 times more likely to get COVID-19. Another study said they're 3 times more likely to get COVID-19.
What's the benchmark, Mr. Rangovitz? Is it when the governor lifts the state of emergency?
Well, I think the benchmark is really when the pandemic is over, when we've reached a level of herd immunity, either by virtue of
no, I think we need something more specific than that. I mean, how are we to declare the crisis over with herd immunity, right? I mean, if we have to look at general risk, isn't that more of isn't that better guidance to look to see whether or not there's still a state of emergency?
Well, I think that's certainly a consideration, but I don't think that's the only thing, because we know there's an elevated risk in carceral facilities. So even if the risk is maybe tolerably low that we're resuming a somewhat normal life on the outside, as I said in my brief, it just takes one person to bring it into a carceral facility. And just relying on sort of one-time testing that happened here is sort of fundamentally flawed. The testing that happened was over 3 months ago, so it tells us nothing about the current conditions in Cedar Junction. Testing, it doesn't predict the future, it really just describes the past. And they're not conducting any testing of staff, which you see in these weekly reports. They're not conducting any testing of visitors. And I think there's also a really big false negative problem that I relegated to just a footnote of my brief, but it's a really important point that I wanted to make sure to raise today. Antigen tests can have false negative rates as high as 50%. And if you want more information on false negatives, I would really urge you to read the amicus brief submitted yesterday in SJC-12977. It's Commonwealth v. Pope, that makes this point really compellingly as well. What you need is repeated, consistent testing to get over that false negative problem. And we know you need repeated testing because that's what we do to protect congregate environments that aren't prisons. Tufts tested students every 3 days.
You're well over your
sorry?
time, Mr. Rangovich. Does anybody else have any questions? Thank you. I think it's Ms. Sprague.
Good morning. Thank you, Jennifer Sprague for the Commonwealth. It's the Commonwealth's position that the single justice of the appeals court properly revoked the defendant's stay of execution that was ordered by the trial court judge. The single justice had the authority to choose either a de novo or abuse of discretion standard, and she chose to use de novo. The single justice determined that in light of the strength of the Commonwealth's case, the decision by the motion judge, as well as the decision by the trial judge on the motions in limine, coupled with the reading of the entire trial transcripts, that the defendant had not shown a reasonable possibility of success on appeal. And the Commonwealth's strength of case lies in the fact that the defendant admitted to these crimes on videotape. The defendant's DNA was found on the victim's genital area, and the defendant recorded himself raping the victim. Now, the single justice was correct when she stated that when considering whether there's a reasonable possibility of success on appeal, that's a purely legal question, which requires de novo review. She didn't say that she was required to exercise de novo review for the entire case. It was just on that one legal issue, because when it's solely a legal issue, it has to be reviewed de novo to see if there was legal error. I believe she was also correct when she stated in her decision that if there is no reasonable possibility for success on appeal, then the analysis should end. Because motions for stay are granted because a conviction can be overturned, but time served cannot be given back. So if there's no reasonable possibility for success on appeal, then there is really no or minimal chance of serving unjust jail time. And if your only grounds for the stay is COVID, then that's a medical issue that should be dealt with a request for medical parole. It's a separation of powers issue. Now, despite the trial judge describing this offense, I believe it was a quote unquote one-off, the single justice described it as a serious sex offense. And this court recently described it as a serious offense as well, when it listed rape among other charges as one that does not, even when merely charged with the offense, does not entitle the defendant to a rebuttable presumption of release. Now, as far as the COVID risk, the single justice correctly determined that there was no specific risk for this defendant. He just turned 35. He has no medical condition that would cause a substantial likelihood of serious illness or death would he contract the virus. And as far as general risk, he was housed at Gardner. He would return there. There have been 0 positive tests within the staff or the entire inmate population. And they have done multiple tests, with the last round, I believe, being completed on August 24th. And I checked the numbers yesterday, and there's still been 0 positive results. So therefore, I ask that this court affirm the single justice's opinion. Now, open to questions.
I guess I'm wondering about using numbers that tell that give a snapshot of what's going on at one particular time, when things could change, you know, at any time. And I guess I'm just wondering to what why should the single justice be looking at the health of the defendant as if they're healthy, as a reason to go back where they may become sick, you know, versus looking at somebody who's sick and saying, well, that's a good reason, that's a reason not to put them back in that environment. It seems like we know that any healthy person can become ill, right?
Yes, I think when you look at the numbers specifically for Gardner, while the numbers I just gave are a snapshot of the current time, I think it's worth noting that this has been their status during the entire pandemic. They have not had a positive result this entire time. So I think it's more than a snapshot, at least in terms of Gardner. Now, as far as, you know, how to look at this, you know, anything could happen. Yes, anything could happen, but we really have to look at what's happening now. And if we didn't have these guidelines, you know, considering specific risk of age and physical condition, or the general risk, how do we decide who gets out and who doesn't? There has to be some guidelines, because if there aren't, then you basically could let anyone out of jail. And again, if there's no reasonable possibility of success on appeal, now we're making decisions on medical reasons, which would be, you know, a separation of powers issue. I believe in CPCS versus Chief Justice 1 and 2, this court found that they didn't have the authority to grant someone medical parole or grant someone an extension of the 60 days under Rule 29 to ask for a revise and revoke. So I think, I hope that answers your question.
It does, but just back to the reasonable possibility of success. Ms. Capiccio said that it's about whether or not it's a non-frivolous claim. It's not about whether or not the claim is going to be successful. So please, can you just tell me why that's not the standard we should be looking at?
Yes, Your Honor. I believe it's Commonwealth versus Levin, 7 Mass App Court 501 from 1979 that said it has to be something higher than a frivolous claim, but less than a high probability standard that's used by the federal government. I think what you have here in this case specifically, I think the Commonwealth prevails on the issues that defense has raised in their appeals court brief. However, even if the court were to find an error in the trial, there's overwhelming evidence of guilt in this specific case. And so I think the single justice had the entire trial transcript. She had the decisions on the motion to suppress. She had all of that was before the trial judge. And she determined in her review that there was no possibility of success on appeal.
So did she, I have a question.
Yes, just like.
Can I follow up on that? So what did she determine it on? What was the standard review she used? She said, just in terms of the cases, you said Levin has to be more than something really substantively. I wanted to know what it was that the judge did, and what did she apply? Did she say it was frivolous? Was she at that?
I think what the single justice did was look to see if there was a reasonable possibility of success on appeal. And to do that, she looked at the trial transcript. She looked at the decision on the motions to suppress. Without getting too much into detail on that, the defendant signed a consent form giving the police the right to search his phone. And it's on that phone that the videos he recorded of the rape were found. She reviewed the trial judge's determinations on the motions in limine, and she, after reviewing all of this information.
Yes, I understand. I'm just asking you what standard she used. Did she say that it was going to be at least frivolous? Was it frivolous? Which, in her view, was it frivolous? Do you think?
She did not put that in her order, and I don't remember her saying that during oral argument. The only
I just
information
wanted
we
to know,
have,
I guess my question is whether or not we need to address this in our opinion about setting what the standard, because you're citing to an appeals court opinion. Was something that the
right, and I do think it has to be something more than a frivolous claim, but less than the federal standard. I'm not sure if this court wants to clarify that, and I don't know specifically what the single justice's thought process was on that.
Okay, thanks.
In the time you have, I know you're over time. Let me just ask you perhaps a last question, Ms. Sprague. Your position that this is really an issue of medical parole, isn't that entirely inconsistent with what we said in Christie?
My point is not that.
I mean, you made the separation of powers argument, but we said the exact opposite in Christie.
And let me make it clear, I'm not saying that considering COVID is a separation of powers issue. What I'm saying is if there's no abuse, if there's no reasonable possibility of success on appeal, then the only other concern really would be the COVID issue, which would then make it a medical issue, because states of execution are supposed to deal with errors in convictions. So if there is no error in the conviction to be dealt with, and the sole issue is a medical issue, I think that's where you get into the separation of powers issue. If there is a reasonable possibility of success on parole, then COVID should be considered, absolutely.
Any further questions for Ms. Sprague? Thank you, Ms. Sprague.
Thank you.
Knight?
Good morning, Your Honors. May it please the court. Erin Knight on behalf of the Commonwealth in the Elibert case, asking this court to affirm the decision of the single justice of the appeals court, who in turn affirmed the order of the trial court revoking the stay. This court should review for an abuse of discretion, but regardless of the standard of review employed, Judge Locke's order should stand. The defendant here filed a motion to stay a sentence directly after sentencing, which was denied by the trial judge. Following this court's decision in Christie, he filed a motion to reconsider that denial based on the changed circumstances that was COVID-19. Upon reconsideration, the trial judge granted a very limited stay to July 7th. That July 7th date was for reconsideration of the change of circumstances, and he cited the defendant's documented history of diabetes, making him at a heightened risk of infection. The stay was expressly predicated on the defendant's particular health issue and the concern that COVID-19 had, where it was the pandemic was first playing out. And at that July 7th hearing, the judge determined he would entertain a motion to revoke. On June 30th, there was a hearing to address the defendant's stay, during which the trial judge explained that he was tasked with whether or not there was a basis to extend the stay or revoke it. He expressly acknowledged that he allowed the defendant's motion for release based largely, if not entirely, on the claimed risk to this particular defendant of infection or harm if infected. The Commonwealth apologizes to the court that we were not able to get a transcript to this court in time due to the expedited nature of this appeal, but that transcript is being produced for this court. The judge highlighted at that hearing that the prisons had adapted to the COVID-19 pandemic and that he did not base his view of the stay on a view of the appellate issues, and that the concern in April seemed to have been largely resolved by the June 30th hearing, looking at the June 22nd special master's report. So at the time the judge allowed the defendant's motion to stay, the COVID-19 pandemic was an unknown, and at the time of the revocation, it no longer was. Due to the great steps these facilities have taken to combat and keep COVID-19 at bay, the change in circumstances that the original stay was predicated on again changed. And should this court proceed further, the Christie factors still weigh in favor of the defendant's stay having been properly revoked, where the minimal likelihood that the defendant's purported appellate issue has on its merits and that his danger is, he still presents a danger to the community. Due to his convictions and sentence, the defendant's baseline is incarceration. The Commonwealth's concession that he, as anybody, would be safer at home is hardly groundbreaking, but the defendant stands convicted of indecent assault and battery on a child under 14, and the assessment isn't whether the defendant is safer on home confinement. The assessment under Christie is the health risk to this specific defendant if he were to remain in custody, and the general COVID-19 pandemic as it plays out in the prisons. Here, where the Commonwealth's prisons and MCI Cedar Junction specifically have taken leaps and bounds for protection of inmates, that risk to the defendant's health is much lower than it was back in April, and the procedures and protocols are working. So neither judge abused their discretion.
Can I just ask you whether if something were to change it, and obviously something could change at any time, what happens? Does the defendant get to renew the motion?
I think so, Your Honor. And I think that based on this court's holding in Christie, that change of circumstance, that fundamental change in circumstance, here is COVID-19. And as we all know, COVID-19, as the pandemic plays out, it ebbs and flows. There's no denying that. But I think here where the trial judge was looking at that snapshot in time of the time of revoking the stay, so June 30th, he was looking at the June 22nd report. And I would emphasize that this court should look at that particular time in its review as well. The pandemic, as it was playing out in Cedar Junction specifically, had flatlined. Now, the defendant does point, the defense counsel does point to a recent positive case in MCI Cedar Junction. But what I would say to that is, first and foremost, either review for de novo or abuse of discretion should be done with looking at the time that the trial judge looked at it. But secondly, that new one positive case has been contained and hasn't spread. And I think that's huge for the way that the prisons are adapting.
I'm sorry, I'm confused because, so you're saying if something has changed, you can ask to get out again, but you may not get out because the reviewing judge is going to look at what the trial court judge had in front of him or her. Is that right?
Well, I suppose so. I think the motion in the first instance would still go back to the sentencing judge, the trial judge in the first instance, whether it's a renewal or if the defendant brings an entirely new motion. It's based on change of circumstance. So I think it would be addressed whether or not, say, take this case, for example, whether or not we're here in the SJC, I still think if the defendant were to return to prison and things changed and he wanted to renew his motion, I think it would go back down to the trial judge who's on the forefront of how COVID is affecting prisons, who sees these motions every day.
The only problem I have with this is that, you know, now we know more than we did a couple months ago, right? And we know that there, you know, there can be like a 2-week period. So, you know, in a couple weeks, we may see a resurgence in cases because of Labor Day weekend, right? And once you see the resurgence of cases, it's too late. It's too late. And then how does the defendant, by the time the defendant gets in front of anybody, the situation will change yet again. And it just doesn't seem like it will have the effect that we meant it, Christie, to have if we are looking at a snapshot in time and pretending that that this pandemic is not continuing to be a problem.
I understand Your Honor's concern, and I do share that concern. I think abuse of discretion review-wise, anyway, you have to look at the snapshot in time that the trial judge was looking at. The overarching issue for Christie regarding the pandemic itself, I think there has to be some, not necessarily end, but some guide as to how we do start revoking these stays if they are predicated on the health issues and COVID-19. And if COVID-19 is being kept at bay, is being isolated in these prisons, as the new case can show that there's only one new case and it hasn't spread, that's showing that the protocols and procedures in these facilities are working. And if there is some sort of outbreak or reintroduction into these facilities, they have protocols in place to take care of that. And I think Foster helps outline that as well. And I think that if there is a lack of testing, as my brother points out, that there haven't been many tests conducted of the entire population as a whole, that's because newly admitted inmates are being tested and quarantined before they're allowed into the general population, negating the need for necessarily more testing in that regard. So I don't believe that it's an oversight of lack of testing. It's just kind of how we're dealing with the pandemic and dealing with testing generally. And I think that's kind of how it's dealt with on the outside as well.
Thank you.
You're welcome.
Justice Flake.
I just wanted to be sure that I understood that you're in agreement with Mr. Rangovitz about we're reviewing the motion judge's ruling and not the intermediate appellate court.
I believe that this court should be reviewing for an abuse of discretion on behalf of the single justice who reviewed for an abuse of discretion in the trial court. I think that where the single justice of the appeals court reviewed for an abuse of discretion, this court should do the same. But under either de novo review or abuse of discretion, the factor here that the judge gave to grant the stay was COVID-19. And I think looking at that snapshot that Judge Locke had in front of him, the evidence as it played out, the facts that he had in front of him at that June 30th hearing that he held because of wanting to review how COVID-19 was playing out, I think under either abuse of discretion or de novo review, this court can affirm the revocation of the stay.
Thanks.
Just slowly.
Do you agree, Ms. Knight, that even if there's no COVID-19 in a particular institution, that Christie talks about evaluating the risk of COVID-19 in general and minimizing the spread in an institution, and that the general risk of COVID-19 is not the only factor? Certainly the specifics as it relates to the particular defendant is a factor. And maybe you're even right that the strength of the issue on appeal is dispositive. But no matter what the issue of spread is in the particular institution, doesn't Christie say that we are concerned about minimizing risk, and the fewer people in the institution, the less the risk?
Yes, Your Honor. I think that plays out generally anywhere, as you can see by the governor's guidelines for social distancing and meetings and parties and things of that nature, keeping the amount of people in attendance to a minimum. However, the baseline assessment for Christie is not whether or not the defendant or anyone is safer at home. It's the health risk to the defendant and the general population if he remains incarcerated. And here he stands convicted of indecent assault and battery on a child under 14, and therefore that baseline is incarceration. Now here, Judge Locke gave this, granted the stay originally based on his health factors and the unknown that was COVID-19 in April. But here we can see that the protocols and procedures are in fact working, that the prisons have put in place, so that general risk is also lower. Not only is the health risk to the specific defendant lower due to those procedures and protocols, but the general risk overall is lower, as shown by the minimal cases that have come to be since that June 30th date.
Anything further? Thank you, Ms. Knight.
Thank you. I'll rest on my brief.
All right, that concludes the hearing. Thank you, counsel.